Hello, everyone, and thanks for joining us today. I'm Mallory Hendry, Content Specialist for Canadian Lawyer Magazine, and I'm excited to introduce today's webinar, The Top 10 Things Estate Professionals Should Know About Death and Capacity. We have two great speakers to discuss this topic with you today. I'd like to introduce Kimberly Whaley, founding partner at Well Partners, and Ian Hull, co-founder of Hull & Hull LLP. Over the next hour, these leaders in their field will delve into the most relevant issues and considerations and discuss what estate professionals should be paying close attention to. Throughout the presentation, Kimberly and Ian will participate in a question and answer period, so be sure to type any questions you have into the Q&A box within the webinar software. I'm going to turn things over to the experts now to begin the presentation. Take it away, Ian.
Thanks so much, and welcome, Kim. This is a great opportunity for us to see each other on Zoom and also talk about some fun issues that we deal with every day. When we were organizing this seminar, and Kim and I were trying to think of what way to cover as much as we could in an hour and also accommodate questions, which we want to do. 10 was probably an ambitious number. So we're going to get through as much of the materials we can. Our materials sort of set out the core of the information, but there have been some changes even since we've started. And one of them, of course, is that we have seen Bill 245 receive royal assent in part. On April 19th, 2021, Bill 245, which significant changes to the estates law in Ontario have been established, and I'll just highlight them, and Kim's going to talk about it right off the top. One of the most important ones, the Succession Law Reform Act has been amended to allow for remote witnessing of wills permanently. We've had that created in COVID, and now that's permanently. Section 16 of the SLRA, which provides that revocation of a will upon marriage has been repealed, and that's an important one that Kim's going to start with. Separated spouses have been dealt with under the amendments, and the provisions under the Succession Law Reform Act now allow for substantial compliance in the execution of a will, and finally, there's been an express exclusion of separated spouses from inheritance as a consequence of Bill 245. This act is a great start, and kudos to the Attorney General, who is the first Attorney General since, I think, Roy McMurtry, who's actually started to pay attention to some legislative changes. So we will move on now to Kim. And Kim, if you don't mind, we will start with, and I'm on slides, so let me not mess up this already. I will, what we're going to cover, and we'll turn to topic number 1.
Great, thanks, Ian. I'm going to spend a bit of time on this topic only because it's a bit near and dear to my heart. So obviously we talk about death and capacity. Some of these issues arising out of, for example, predatory marriages, we don't find out till after death, but some we do find out through capacity issues during life. And so we continue to see increasing numbers of these common law relationships, and many couples who live in spousal-like relationships don't feel the need to formally marry. And so we see, first of all, misconception about property rights arising out of these two types of unions, and then issues with respect to revocation. So in Ontario, marriage has had the impact of automatically revoking a will on marriage, and this was previously pursuant to Section 15 sub A of the Succession Law Reform Act. The exception, of course, would always have been when a will was done in contemplation of marriage, and other provinces have never, some other provinces in Canada have never actually ever had these revocation provisions in their legislation, and more recently, some provinces have reformed their legislation, for example, in BC and Alberta, and we've seen some reform out of Saskatchewan. As Ian mentioned, our new Accelerating Access to Justice Act 2021 brought our province into line with some of these other provinces, and the current state of the law and different capacity criteria at common law and statutorily permit individuals to revoke a will through marriage, while at the same time lacking the requisite capacity to do a new will, which wreaks havoc on the estate plan. But Schedule 9 to Bill 245 is in part aimed at protecting vulnerable elders against predatory marriages and those that are entered, obviously, for financial exploitation. So once in effect, Bill 245 repeals this section. It doesn't come into effect, however, until January 2022. Some of the other provisions of the bill come into effect before that. For example, if we look at the current entitlements of married spouses on death, if a person dies in Ontario without leaving a valid will, a common law spouse will not have automatic rights to the deceased spouse's estate. In contrast, a married spouse is entitled to an interest. So one of these recent changes is to the preferential treatment. So the preferential share, it's now increased from $200,000 to $350,000 for estates of persons who die on or after March 1st, 2021. So a spouse is entitled to that preferential share. 1/2 of the balance if the deceased has one child, or 1/3 of the balance if the deceased has 2 or more children. Similarly, we know that only married spouses are able to elect under the family law provisions of sections 5 and 6. And the rights of common law spouses, by comparison, there's no automatic rights, but that doesn't mean that a common law spouse can't take advantage of Part 5 of the Succession Law Reform Act and make an application for dependent support. And of course, the legislation provides for 19 factors in determining whether adequate provision for support has been made. And there are other factors, including moral factors, arising from our Court of Appeal decision in Cummings and Cummings. Bill 245 does not affect the rights of common law spouses. And now, before leaving this topic, I just want to talk about Tanti and Tanti. You'll see the reference on the PowerPoint. It's the latest in what's become a long list of cases involving a marriage in which one spouse is much younger than the other. Typically, a child of the older spouse seeks to have the marriage set aside on the grounds the older spouse lacked capacity to marry. In the process, there's all sorts of ugly allegations of predation and gold digging. And although Tanti wasn't necessarily a predatory marriage case in the true sense, it had the appearance of it. So Paul Tanti was an older gentleman who married his much younger living companion. They met in 2014. By 2017, they began to refer to each other as companions to all those who knew them. In 2018, they moved in together. Paul eventually asked Sharon to marry him when he was 89 years old. They were married in July 2019. Witnesses who attended the ceremony testified that Paul was able to answer the minister's questions. There was no issues with the ceremony. But Paul's son, Raymond, wasn't happy. He came to the house in late July. He did not like the fact that his father married. He called the police. There was an abusive interaction. After the marriage, Sharon left on a 2-week planned vacation. And during that time, Raymond, the son, took various steps to undo the marriage. So he took his dad to a gerontologist, in fact, 3. And their gerontologists offered various opinions about retrospective capacity, not necessarily on point to capacity to marry. So in August, just a month later, Raymond moved his father into his home while Sharon was still out of the country. And he brought an application for a declaration that his father was incapable of managing his property, his personal care, for guardianship, for custody, in order to sell his father's house, freezing orders, etc. And the application was granted. Then Sharon came back, and meanwhile, Section 3 counsel was appointed for Paul. There was a video conference hearing later in the fall, and the court found there was absolutely no evidence that Sharon, who was alleged to be a hired caregiver, was in fact a caregiver, nor was there any evidence that supported the allegations against her. And in discussing the law on capacity to marry, the court referred to some of the recent cases, but determined that there was no predatory marriage and did not give weight to their gerontologist reports nor to the retrospective assessment, and concluded that Paul had the requisite capacity to marry in spite of all of the evidence put forward by Raymond. And the court said, and this is the interesting dilemma in the common law treatment of predatory marriages, that marriage is a simple test not requiring a high degree of intelligence. And of course, I don't, and I'm sure Ian doesn't ascribe to that, because in fact, significant property rights do come to married spouses. And so in my respectful view, a person who's entering into a marriage not only should have the capacity to enter into a contract, but also be able to manage their person and their property. And indeed, Justice Cullity referred to these principles obiter as long ago as the Banton and Banton case. And so that's your update on capacity and predatory marriages. Over to you, Ian.
I just want to follow up on your comment, Kim, that you say that, of course, capacity to marry and the level of the test is been, I think, belittled a little bit in some respects by the court at some level with some of the decisions. Now that Ontario has caught up with much of the rest of Canada with the amendments to the legislation with regard to divorce, remarriage, revoking a will. Do you think that's going to change the perspective at all of the property rights? Obviously, it diminishes some of that concern, doesn't it?
It does, but in my respectful view, it doesn't go far enough, because it's not going to prevent these unions. It might do away with the revoking of a long-standing estate plan, but still, married spouses have significant rights apart from that, and whether there's a will or there's no will, and the ability to gain property rights through joint ownership and through use of a power of attorney, etc. So it doesn't solve the problem. It's one step, and I hope our AG will give us some more attention, and we can develop a Predatory Marriages Act, which my colleague, Professor Albert Osterhoff, has drafted. It's been drafted for some time, and we're trying to push that forward to help dispel this common law old age test that marriage is a simple test. It's not really a test per se, but and it's not simple. It's not simple because we know that property rights are tied to that union.
Well, that's a good one. We'll look forward to it. And if there's an AG out there that'll listen for now, it's going to be Doug Downey for sure in Ontario. But across the provinces, we in Ontario need to be pushed a bit. And I know British Columbia is famous for pushing us in the right direction on some of these amendments. And Alberta has long caught up, and down east they have too. Yeah. All right. So I'm going to talk just about that to tie into the next topic about the impacts, how divorce impacts on state distributions. And divorce, of course, in contrast, doesn't invalidate the will, but divorce revokes particular sections of the will, and unless there's a contrary intention in the will itself. But the legislative change that came up in Ontario, which again brings out this whole question of testing parameters of the distributions within a state, is that separated spouses from whom the deceased was not divorced may still have rights on an intestacy, and pursuant to the will, or even equalization rights, which you talk about there a moment ago in terms of these special property rights that exist, depending on the timing of the separation. And the new legislation actually goes on to define in the SLRA amendments that talks about separated spouses will be precluded from electing under the Family Law Act, but what is a separated spouse? And I just think this is certainly helpful guidance for all of us when we're dealing with state administration, touchy state administration issues where we've got relationships that may or may not be in flux. And in the new legislation, they talk about they have to have lived separate and apart. as a result of breakdown of their marriage for a period of 3 years. And if the period preceded immediately prior to death, they have to have entered into a valid separation agreement under the Family Law Act. And that valid separation agreement are pretty broadly litigated over words. What is a valid separation agreement? And then, of course, the rights that fall from that. So, you know, from our standpoint anyway, as we're catching up to the rest of Canada on this new legislation, there are gaps, like you've described. There's a gap in respect of what does a separated spouse look like or not look like. And then, of course, divorced spouses in Ontario continue to have the same ability to consider a dependents relief claim under the Part 5 of the Succession Law Reform Act, and the similar provisions of that are, of course, in the legislation across Canada. You know, this whole concept of dependents relief is something that has been carefully structured through statute for many, many years. Since the 1905 we started in Ontario, and most of the provinces were created around that time. All right, so Kim, I'm going to try to remember to advance the slide this time. Number 3, whoops, I went too fast. So number 3, can we talk a little bit about wills and other testamentary instruments that are challenged?
Sure. I know that you certainly must be seeing this in your practice. Ian, planners or family law lawyers often will retain us to assist with bulletproofing or getting an ironclad estate plan. And the reality is that it's impossible. Of course, we can do our due diligence and go through all of the identifiable iterations of what a challenge will look like, who it will come from, but we can't stop the challenges at the end of the day. We can only try our best to prepare an estate plan in accordance with our clients' wishes that will withstand the test, I guess. But we frequently see will challenges, and some of the grounds we see them are on, for example, not properly executing a will in accordance with the formalities of due execution, lack of knowledge and approval of the contents of the testamentary document, lack of, I was going to say lack of testamentary capacity, which is a big one. Allegations that the will was procured through undue influence. We also see that quite a bit. Of course, this could be coupled with suspicious circumstances, which is an evidentiary consideration and not necessarily a ground, and maybe less frequently so, but we do also see wills that are contrary to public policy, or we see fraud, forgery allegations. And if a will is declared to be invalid, we sometimes have to look at the terms of the prior will. It may prevail, or of course there may be an intestacy and we have issues trying to identify beneficiaries as a result of that. There are all sorts of other types of challenges. For example, dependent support claims, unjust enrichment claims, constructive trust, quantum merit claims, notices of contestation, negligence claims, and then a big one, Ian, that we see also arising more frequently are the mutual wills. So sometimes couples, especially in later life partnerships, will try to preserve their wealth so that their family benefits, and so they do mutual wills, which has to be more than a mere will, in that there is a contract that goes with these mutual wills. But sometimes once the first spouse dies, what is supposed to happen doesn't actually get carried out, and we see new wills being done by the spouse, which is obviously the surviving spouse, which is contrary to the contract. But nevertheless, it happens, and we see quite a few of these disputes. So, Ian, I think you were going to talk to us a bit about domestic contracts in all of this.
Sure, and just tying into that last point, because it does talk to, if a mutual will arrangement is going to be established, one could, of course, contract to create an agreement not to change your will, for example. But the most typical and effective mutual will agreement, where we have a second marriage, for example, and you want to make sure that each of your streams of wealth will pass to your respective families, is, of course, through domestic contracts. And it's a tool that, lots of clients will say to me, they'll come in and they'll say, well, look, how do I arrange this so that essentially my husband or surviving wife doesn't stiff my family? And you're sitting across the table, of course, in a bit of a conflict, because you've got, potentially anyway, you've got the surviving spouse in front of you, and one of them is going to be a surviving spouse, you hope. So I often will just say, look, that's where domestic contracts are so important to ensure the flow of the assets. In Ontario, for example, though, of course, the testing of those is done typically in the family courts, where the validity of those on death can be tested by virtue of lack of ILA or disclosure, all of the classic tests that a family law lawyer would attack a domestic contract on a marriage breakdown. But also in Ontario, we have a unique situation, not that unique actually, but we have a unique situation where we have an ability where the legislation provides that the court can accept and enforce a domestic contract or a marriage contract, or the section right after it, section 62 and 63 of the Succession Law Reform Act, says the section right after that says the court can ignore it. So the court is given broad scope in that context when you've got a situation where a domestic contract may be in existence, may have been created properly, and may have met the test during lifetime, but it may not meet the test on death. And in large part, that uncertainty comes as a consequence of the competing legislation. There are also other attacks. So again, just coming back to that point, we think we've got it all tied up like a bow. And as you described, Kim, you're sitting there going, okay, well, I've done much bulletproofing as I can. And in British Columbia, of course, they use the alter ego trust as a tool to really strongly bulletproof arrangements, especially in second marriage situations, second relationship situations. The alter ego trust is a tool that they've crafted and has been embraced as a real protection to their what used to be called the Variations of Wills Act, because they of course were met with challenges to domestic contracts, wills, and so forth. Well, in Ontario and across Canada, the Moore versus Sweet decision illustrates another Supreme Court of Canada decision on Moore versus Sweet. It illustrates another prospective attack on a bulletproof estate plan. And in that case, literally in the face of an insurance declaration, the Supreme Court of Canada, for good reasons, and I won't go through all the facts now, held that the recipient, that the concept of unjust enrichment should apply in respect of certain insurance proceeds, and allowed it to disregard the irrevocable designation that was made. So in that case, an irrevocable designation was made, and the Supreme Court of Canada found a way around it by using the concept of unjust enrichment. So I think we can see the uncertainty that can get created. These documents are not going to be the be-all and end-all. And interestingly, of course, the Dagg versus Cameron decision, which is dealt with in our paper, actually clarified the law a little bit to allow for the protection of support orders having been obtained pre-death to survive in priority to dependent relief claims. So that was where the court kind of said, look, if you're going to have arranged those affairs by virtue of that arrangement, then the dependence relief claims might got pushed to the side. So I think the broad scope of the court and of course the legislation across Canada is so widely drafted in respect of rights under the dependence relief provisions that you're never locked down. And as I say, the Moore versus Sweet decision talks about the fact that you can get all the way to Supreme Court of Canada and find out you're not locked down. Yeah. All right. So I want to move on to item 5, where we're right on time. So I'll try to keep with these questions as we go along too, but go ahead, Kim.
So another opportunity a married spouse has on the death of a spouse is the opportunity to make an election and corresponding application under the Family Law Act. This has to be done, importantly, within 6 months of the date of death. So the survivor may choose to take the gifts in the deceased spouse's will, if there is one, or receive an equalization of net family property, similar to what would happen on a divorce. The decision to decide whether to elect or not is a difficult one, and the spouse is going to need to weigh the options available. And in that regard, we'll need certain information from the estate trustees or fiduciaries of the estate, and understand what the estate, the scope of the nature and extent of the estate of the deceased is, to determine whether or not an election is worthwhile. So there needs to be an analysis of that information. Sometimes, because of the nature of the estate, that information is not readily or immediately available. And so it's important that if you're acting for a surviving spouse, that you either by consent or through an application, which may be contested, although I'm not sure why it would be, obtain in order to extend the election period so that you are preserving the rights of the spouse on death. It can be contentious, especially because the beneficiaries will be looking to the estate trustee to preserve the estate, the testamentary intentions of the deceased, and often these elections, the beneficiaries or ultimate beneficiaries named, they want to resist these sorts of claims. And so it can be contentious, but as a fiduciary, irrespective of your obligation to protect the estate and the testamentary intentions of the deceased, you have to act reasonably and properly in getting disclosure to the spouse in these circumstances. So I think we're switching up a little bit, Ian, and you're going to talk to us now about digital assets, which are becoming more and more important in estate planning and estate administration.
Absolutely. So this topic is a bit near and dear to my heart, but not near and dear as it is to my partner, Susanna Popovic-Montag and Nick Estabauer. They both penned a superb article in the Estates, Trusts, and Pensions Journal, which I didn't put on the slide. I apologize as a source, but I highly recommend it. It's a comprehensive review of the law and some practical suggestions. And I think what I wanted to just talk a little bit about, a little bit of the history here. We've got a link to what is an important Uniform Act that I'm going to talk about in a moment. But so first of all, the value of these assets are, there was a study done by McAfee, who are the big software security company back in the around 2013, and they established that the average North American holds digital assets valued at approximately $46,000 US. So that was just an illustration for me to say, boy, this is a much more serious problem for our clients and also for me. And so my concern and my focus turned on digital assets in respect of the planning stage and how to best protect ourselves. There is some legislative assistance out there. The Succession Law Reform Act doesn't really help us in Ontario. There's been the Uniform Law Conference of Canada introduced the Uniform Access to Digital Assets by Fiduciaries Act. And I think it's, as I just checked, I think as of now, it's Saskatchewan's the only one who's embraced it.
That's right.
We'll be putting this on the list to the Attorney General in Ontario. But it's just a phenomenal piece of legislation. And it actually maps onto, again, the U.S. are way ahead of us on this because they've had uniform acts, revised acts and uniform acts already throughout the U.S. But basically the goal of these acts is to facilitate fiduciaries access and custodian disclosure with respect to privacy and the intent of the user. So what does that mean? It really means is that what can we do as lawyers looking out for this issue is, of course, is that we want to look at the steps for planning and administration that we're going to have to deal with on death. And that is, of course, looking at recognizing what are the digital assets of our client, accessing the digital assets, how are we going to ensure that they're accessed, deactivation and preservation of the digital assets. And of course, each of these companies have their own methodologies to deal with digital assets, but Google and Facebook, Google more so, they have an inactive accounter manager which allows you to use the tool pretty easily to transfer the information. But some of the more prominent Twitter as well are starting to at least acknowledge that they're gonna have to have some sort of transitional ability other than calling them up, which, as you can imagine, phoning Facebook is no fun. As an executor. So the last part of this I just wanted to highlight, though, is, of course, what is it, from Ontario's standpoint, these are assets that attract probate fees. So they can't be completely ignored, certainly, since we've created the new regime in Ontario where every estate trustee can be audited through the Minister of Revenue. Before, the audit was semi-available, but now it's implemented and implementable, and of course subject to sanction if you don't properly list your assets. So these assets are not to be just sort of flippantly dealt with as an executor. So what often you want to do is, when you're talking about the planning considerations, and this is something that Susanna's article goes through. It's the Estates, Trusts and Pensions Journal, and I'm sorry I forget the site, but easy to find through that journal because their articles are. It's not a giant voluminous source, but what they did was this: they started to say, look, sorry.
Is it listed on your website, Ian? The TPJ reference?
Yeah. Yes, it is. Thank you. Oh, good thinking, Kim. Thank you. Good save. Okay, so what this article I think is what helped me anyway is that it actually sets out some checklist type steps, and we use eState Planner and our firm to do our will drafting, and so we've incorporated all of this into our software, these steps, but of course just a conventional methodology of determining this is also available. Do you have any assets listed and what are they? Look at the devices, look at the the content, look at whether or not you've got domain names, whether you've got any trademark issues and so forth. And then access. And does the your survivor have access to the digital assets now, or will they be able to on death? And have you put in any plans to transfer the information that's stored digitally? Do you have any valuations of those assets that may or may not exist? Do you have online accounts that need to be deactivated immediately? And I find this is an interesting one because, of course, there are obviously situations on death, but a friend of mine just recently got appointed as a judge, and I checked the webpage, the firm webpage, to send a note of congratulations, grab the email, and they'd already literally within an hour of the appointment taken down the bio on the webpage, because of course when you're appointed to judge you can no longer practice law. That all makes sense. Well, there are situations when you're in an estate situation where you do need to consider whether or not there's an urgent need to bring down or deactivate some of the digital assets that may or may not exist. And then, of course, the educating your executor, as I just described quickly, was Google's is it's one of my favorites because it's got inactive account manager tool that is actually user friendly and can be a tool that you don't need to have gone to 4 years of university to figure out, or don't have to sit online or sit on a phone for 4 hours to talk to somebody. So some of these programs actually have got ahead of this in terms of their consideration. The last point is that, and the paper is great for us, is that it's got some specific clauses to consider into putting into your drafting for estate planning purposes in respect to digital assets, and we've taken those clauses and inserted them into our eState Planner. that we use, because it's something that if you click that button, if whatever software you're using, you're going to remember to include what can be an important asset, and what also I don't want to be criticized later for having taken either too lightly at the time of the planning, because it's worth more than I anticipated or I ever thought it was, and then therefore it creates a problem on administration. So digital assets are something that, while not every one of our clients is in that sphere, many are. And as I say, I'm just being asked a great question, and I'll just say it one more time with the Google example, and I'll look at my paper again, or Susanna's paper again, to double check what it's called, but it's an online, it's called Google Inactive Account Manager. So Google Inactive Account Manager. And there we go. So that's a little different twist on some of the important assets that are, some of the important issues that are facing us as lawyers today. We've got some legislative changes, and then we've got, of course, the internet, which is going at full steam. So, Kim, let's talk about mental capacity. Or go ahead.
Ian, I was just going to say, it's really interesting, all of the digital assets forum, because it seems to be changing fast, but in many respects at a slow pace, because I'm astonished that there isn't more legislation at this point. Just before we go, and maybe you haven't answered this because you don't know the answer, but I don't know the answer. One of the questions asked by our attendees today is, will the Federal Digital Charter Implementation Act apply to Ontario estates and digital assets when it gets its final reading? And if so, will it make it easier for executors? I don't even know about that act. Do you? Have you heard about it?
Well, it's funny. I did. I have, and I read about it today a little bit on it, because it's not supposed to affect social media. There was a good article in the Globe. I don't think it's going to have any impact from what I've understood of my first go through of it, but we're going to see. And I think it's still going to come down to a provincial attention to it, and it's on my list to approach the Attorney General as well, even if we can at least identify it better in the Succession Law Reform Act with some tools. I want to just thank Daniel Walker. You're a saint. You put up my article and the link to it. So there we go. And in it, we have some more discussion on the Uniform Act, which is really very important. So sorry, go ahead, Kim.
I didn't know about Susanna's paper either, so I'm gonna, and Nick, so I'm gonna get a copy of that and read it. Thanks for the reference. So I think we're going to talk a bit about.
Well, thanks to Daniel.
Yes, thank you, Daniel. We're going to talk a bit about capacity. Obviously, our program is about death and capacity, so we'd be remiss if we didn't have a few things to say about it. First of all, everybody needs to know that there's a presumption of mental capacity at law, and under our Ontario legislation, the Substitute Decisions Act, Section 2 addresses this presumption. Frequently, however, we do encounter situations where the circumstances are such that capacity of a party is called into question, whether that be in litigation or otherwise, and associated with that are challenges to transactions and allegations that the individual lacked capacity to enter into a certain transaction. And so we must always remember that capacity is time specific. In other words, at the time that the decision or task is being undertaken is the time that capacity will be examined. It's situation specific. So sometimes external factors and stresses may impact whether a person is at their best at the time because of the situation that they're in, and maybe anxiety related to that situation. And it's task specific. So what decision are we talking about? Are we talking about marrying or gifting or doing a will or a codicil or granting a power of attorney for property or for personal care or managing property? So all of these different decisions or tasks carry with it different criteria to determine whether or not the requisite capacity exists. That's in spite of the presumption. So know that a lot of these criteria come from common law and not from statute, although we do have some statute that assists us with examining capacity. That's not the case of course, with testamentary capacity. And in the wills and estates business, obviously, we're very concerned about that. We still have the case of Banks and Goodfellow with respect to that criteria and determining whether or not a client has the requisite capacity to understand the nature and act of making a will, the extent of one's assets, comprehending and appreciating who is to gain. There's a great article written by Ian Hull and Ken Shulman on this, and having a new look at Banks and Goodfellow. I'm sure that paper or reference is on Ian's website, and I'd encourage you to look at it because it's a fresher look at what is an old case, but has withstood the test of time. So in addressing the issues of capacity to manage property and healthcare decisions in Ontario, we have the Substitute Decisions Act, which is fairly comprehensive. And basically an individual must have the ability to understand the relevant information and appreciate the reasonable, foreseeable consequences of what they're doing or not doing. And historically, some courts have found that the capacity spectrum was on a hierarchy. I don't think that is so anymore. I actually wrote a paper on this with Dr. Shulman. I don't think it's so much a level situation, in other words, levels of capacity, that it requires more capacity to do this or to do that, but rather the question really is, what is the decision or task undertaken? And then you apply the specific criteria to that decision. Obviously, in assessing capacity, we look at a spectrum of evidence, the drafting solicitors, evidence, medical evidence to the extent that it's available, capacity assessments if warranted or undertaken, and of course, layperson evidence. So all of the evidence starts to tell the story when you piece it together and coordinate it. And the key there with respect to all of these issues concerning capacity is record keeping and notes, and making sure due diligence and probing questions are asked when we're trying to assist clients with these types of planning vehicles. So with that, the planning vehicles and tools, over to you, Ian.
Sure, thanks, Kim. I just want to pause on this point here that you're talking about, because it is so important, and that's good. Thanks for mentioning that article that Ken Shulman and I did. It was a group of us. It was more than Ken. Ken was the leader, but we had Justice Susan Himmel's input as well in that article. One of the things that he really focused on, and I thought was such for a doctor, a plain English way of putting it, is that he kept coming back to us on what is the rationale for the change, and is it a consistent rationale, or what is the rationale? And it's obviously when we're taking instructions, when someone wants to exclude someone or wants to do something that is a shift in the planning that has already been done, or maybe something that's a red flag, like excluding a child, even if it's the first time you've done a will. Ken Shulman talks about developing an inquiry into the rationale. And it's just such an important step in any time we're assessing capacity. And when he says that article is Banks and Goodfellow Revisited, it is an article that really just adds on that element of it. Take the core test that's been around since the 1870s and add on the consistent rationale. Is there a consistent rationale for it? And I agree with you 100% on the idea that the hierarchy is long gone, because, of course, in the task specific and situation specific and time specific, an easy illustration is someone comes to see me and they want to do a change of an executor for a good reason, because the executor they've appointed has passed away or can't do it. They've moved to England. Then that's a task that doesn't take the same level of cognition and ability to understand and so forth. We still have to get to the question of testamentary capacity level, but the threshold, of course, is much lower, unless, of course, the situation is that they have are about to appoint someone that they are in, in an obvious, highly contested situation between children or something like that. So breaking down the test of situation specific. So what is going on around the client? So I take notes about what's going on around the client, what's happening in their lives. Obviously, in these times, COVID demonstrates a high level of stress for all of us. Time specific, a will is always tested at the time the will is drafted, and then task specific, of course, what do you want to do? Is it a standard gift over to each other, gift to each other, and then gift over to our kids, or is it more complicated? And what is the task that we're being asked of? So when we do that, though, of course, there are tools that exist to protect. Let me move my slide. To protect the interests of those with diminished capacity. And diminished capacity is used specifically for a reason, because of course it's not for those who lack capacity. Some of these tools, of course, do protect those, but like you said, there's a presumption of capacity. Well, there's also a presumption of capacity, and the courts have consistently across Canada wanted to look at the vital, when we have someone in a diminished capacity situation, what is in their best interest? How can we maintain their own personal independence and freedom? And those overriding and important limitations on capacity analysis are so important to the courts. So these are some tools that regulate it. And across Canada, of course, the powers of attorney do such that litigation guardian appointments across Canada is available. In Ontario, we talk about guardianships through the Substitute Decisions Act, where it is a court-appointed position. We even have in Ontario what is called Section 3 counsel, and it's a little different in British Columbia, but we have this idea where counsel are essentially appointed to protect the interests of an alleged incapable, and that's the language of the Act. And when I say protect, they're there to manage the interests, I would say more accurately, because of course there's a lot of moving parts in the appointment of Section 3 counsel under the Substitute Decisions Act, but that's another special role. So we have abilities to go court supervised, court scrutinized steps that can proceed, and then of course private choices are getting capacity assessments, ensuring that when my client comes in to see me, that if he's giving me instructions, even in litigation or in will planning, that if it is someone who has got diminished capacity and I want to protect their choices, i.e. their choices to instruct me or their choices to change their will or do a will, I'll use the private capacity assessment tool to get an opinion, to have it, the comfort that it's not just my word where I've assessed the question of capacity, it's the words of a trained capacity assessor. So those tools, of course, are there and they're available to be able to protect our interests. Kim, why don't we've got a little over 10 minutes, so we're right on track. Let's move on to number 9, the obligations of a fiduciary, because we've got, this is obviously a heavy topic, but let's highlight on some of the key elements of fiduciary obligations.
Sure, Ian. So particularly when you're dealing with capacity issues where an individual is authorized to assist another in a fiduciary capacity, it's important to be aware of the obligations and duties, and I'm going to say prevailing limitations relating to their authority to act. So we want to look at what the fiduciary relationship is and what the duties and obligations that go with it. It's a special relationship, and we see it in the context of estate trustees and beneficiaries. We see it in the context of solicitor and client relationships, of other professional relationships, as between parent and child, with a guardian, an attorney, doctor and patient. That's just to name a few. A fiduciary duty, however, may also exist in other types of circumstances or situations, such as where an elderly person, for example, or incapable, is vulnerable, is dependent on a particular person. And so then the relationship of trust is there, and therefore it becomes a fiduciary relationship. So the leading authority on this is the Lac Minerals and International Corona Resources case. It was a Justice Sapinka decision. When dealing with one of these traditional relationships, the characteristics or criteria, shall we say, for a fiduciary relationship are assumed to exist unless in special circumstances they are shown to be absent. The area encompasses issues of capacity assessments, and as I said, fiduciary litigation, including powers of attorney and guardianship. There is a lot of case law out there governing the fiduciary obligations. Central to the concept is the fact that the fiduciary has to preserve the interests of the person that they're acting in respect of over their own. And we see that breach all the time. And so those interactions are often characterized as a power-dependent relationship where one party gains power over another and or influence over another. We see the scope of fiduciary duties from common law, and one of the great cases that I always refer to is Eagly and Eagly. But also we see it in Section 32 of the Substitute Decisions Act. There's a number of factors in there that govern how an attorney ought to act when dealing with a person's property. And as advisors, we are increasingly aware of the far-reaching consequences of this practice area, and it's a potential minefield of things that can go wrong. And we have to make sure that we're familiar with all of the legislation and the case law in order to competently advise our clients. And this is so whether or not we're drafting or we're litigating. Attorneys for property and personal care and guardians or estate trustees are accountable to the grantor for all decisions made. And of course, there's the requirement to keep accounts, to account, possibly to pass accounts. There's obviously I'm going to say the thing that fiduciaries ought to be most aware of, and that is the developing case law with respect to cost orders when fiduciaries don't act in accordance with their duties. And we've seen some recent cases on costs which illustrate the serious or importance of the seriousness or the importance of the rule. So I would say make sure you stay up to date on these fiduciary obligations and duties. One of the things that I was going to mention just before I started talking about fiduciaries is when we look at capacity and we look at all of the protections and the criteria, etc., the one thing that I think we often struggle with is this concept of vulnerability or dependency and undue influence, and whether that be of the testamentary nature or inter vivos nature, and the differing tests in that regard. John Poyser and I recently wrote an article. It's not out yet. It will also be in the Estates Trust and Pension Journal, I think the next edition. But it still amazes me that the test, so to speak, or this notion of testamentary undue influence is tied so closely to the notion of coercion rather than the subversion of will. And I don't know if we'll see a change in that in the future, but certainly as our experts, even that we retain to opine on these things, struggle with this vulnerability to influence that is so closely tied with, I'm going to say, capacity and disability and dependence is going to be, I think, an expansive area in the future. I don't know what your thoughts are on that.
Well, no, I agree 100%. And I think it's the other half of the whole analysis that the courts haven't really flushed out over the years, because it really does. It hurts your head a bit. I mean, Justice Cullity in one of his decisions commenting on what what undue influence really is he talks about the concept that you're making someone do what they do not, that is not their choice or will. And that's, that obviously coercion's an easy way of describing it, but you and John have really opened up the second half of the question, and that is that if you're vulnerable, how does that impact on it? And we can get experts who will comment on vulnerability as being a factor to consider whether or not they were unduly influenced. But the big hurdle in all these undue influence cases, of course, continues to be is that it's typically done in secret. So to find the evidence, to even just because you're vulnerable and just because you do something, to find the evidence to link it is always the tough piece of the puzzle, and one that frustrates clients to no end when they come to see us and we say, well, an undue influence case, those are the hardest ones to pursue. And, if you've got some great evidence, I can tell you, I can count on one hand how many times I've ever heard great evidence on the undue influence.
Yeah.
So it's a big problem.
Sure.
Again, thanking Kendall Dick, who gave us the comments on the Charter Implementation Act, focusing on that really being something that's for PIPEDA, and I agree. I haven't seen any of the overlay into the estates side of it yet on it. And then, of course, Ron Usher, thanks again for the representation agreements that need to be highlighted in British Columbia. Of course, when you get over the mountains in British Columbia, things are done better and different. And so we can never forget how better and different it's done. And British Columbia still continues to be, in my view, the thought leaders in terms of dealing with matters of vulnerable and incapacity from a legislative standpoint.
They have great tools as well, and the British Columbia Law Institute in particular, their website has so many tools when you're dealing with all of the concepts that Ian and I spoke of today. And I recommend that highly to you.
Yeah, great point. I use the tool that they talk about, testing for undue influence, and they give you specific illustrations and specific questions in their paper. And one of them is don't be afraid to ask the tough questions. Are you being assaulted? Are you being abused? Do you feel that you're being taken advantage of? Asking really tough questions of the individual when you're seeking their instructions in private, of course. And the checklist that they prepared for the testing undue influence is superb. Okay, sorry.
I was just going to say, I think our last update is on MAID, and I think you are going to give us a little synopsis on that.
Yes. Sure. And I'll just give you a very quick synopsis, by no means the definitive word, because we've got only a few minutes left and we want to keep this on time. Supreme Court of Canada, of course, in the 2015, the Carter versus Canada decision found that competent adults' response to grievous and irremediable condition is a matter critical to their dignity and autonomy, and it started the ball rolling with MAID. Then the Trucon decision out of Quebec that came out in 2019, where they challenged the concept of natural death having become reasonably foreseeable, was amended and by legislation, which again, we've been lucky enough in COVID, amazing things are happening. One other thing that happened here, of course, is that it received royal assent on March 17th, 2021, the amendments to MAID, where they have now created two different sets of safeguards for the question of if natural death is reasonably foreseeable. And the safeguards in place are set out under the legislation. The procedure has been identified. Oops, forgot to change slides again. This is going to be my curse. The procedure has been identified specifically in respect of if the legislation, if natural death is not reasonably foreseeable, what are the safeguards? For example, if it's not reasonably foreseeable, you have a minimum of 90-day assessment period, where if it is reasonably foreseeable, the patient is only required to have one independent witness and not two sign it, and the 10-day reflection period is eliminated. So they've loosened up some of the parameters of it. The key with MAID in the last 30 seconds is this, in my view, is that it's that consent must be given by the person, and it cannot be given by a substitute decision maker. And course, MAID has not tackled conditions of mental illness. They're not eligible, and that's something that's going to be something that we will be considering in the future. So obviously, the MAID legislation is going to be, I think, an organic process, and we haven't leaped, but we're at least running in the direction of some very significant freedoms for people to make those end-of-life decisions. So we're at 12:59, and I want to just, Kim, unless you have any other comments, I want to just wind up.
Okay, no, I was just going to comment on one of the questions, which is Toronto Estates Court doing anything to speed up their application process? They're on it. They were caught up and doing current applications when we last met with the court representatives. And so they're working on it. Look, I have to say that at least our Toronto court and the commercial list that services estates has worked tremendously throughout COVID. And I'm going to say probably better than most other courts. So they're trying their best. And I don't think they're too far behind in terms of probate applications right now. And the other question was, has anyone tried to use a simplified application process? I have not. Have you, Ian?
I haven't yet, no. There's some great questions, Daniel. You're going into a really important dialogue about cryptocurrency and how we're going to deal with that. I think we're going to be seeing digital wills in something in the next 5 years, in my view, and I think we're also going to be dealing with the cryptocurrencies issues front
Say
and
that 10
center.
times quickly.
Yeah, exactly. We're not in any strong position on either of those at this point, though. All right. Well, look, it's 1:01, and I want to thank Kim Whaley of Well Partners so much for taking the time today. It's been a great opportunity for us to speak to everyone and talk about these issues, and we wanted to get 10 ideas in, and I think we got in 100. So thanks again, Kim, for all your help.
Thank you, Ian. Thanks, Ian. Thanks, everyone, for attending.
Thanks so much to everyone for joining us today, and of course to Kimberly and Ian for providing their insight on this important topic. So keep an eye out for other upcoming webinars, and please stay safe in the meantime. Thanks so much, everybody. Have a great day.